Hey, good evening, everyone. Welcome those of you in the room and joining us on Facebook Live for our discussion on BIPA, the Biometric Information Privacy Act. I am going to introduce you to the presenter tonight, our wonderful Pilley Fellow, Joseph Hawkins. Pilley, that's Public Interest Law Initiative. We have Joseph here this summer, partially through them, as well as Mayor Brown, where Joseph will be joining in the fall in the Banking and Finance Division. Joseph recently graduated from Northwestern University Pritzker Law School. He'll be sitting for the bar exam in Illinois next month, and we are very excited to have him here this summer. So without further ado, Joseph.
Thank you, Ben. Glad to be here and glad to be at the Citizen Advocacy Center this evening, and for those of you on Facebook Live watching. So the title of this talk is BIPA, Facebook, and You. Does this Illinois law reasonably protect user privacy or unreasonably prevent innovation? And this is something where, well, before you came in tonight, maybe you didn't know what BIPA is, but you're going to know a lot about what it is after we're done this evening. One thing I want you to keep in mind as we go through this talk and think about these issues in privacy is that, I just graduated from law school, about to take the bar, and as I think about different legal doctrines and how we think about the law itself, sometimes you try to put these doctrinal hooks in your mind of this is a privacy law, this is a property law issue, for instance, right? When somebody trespasses on your land, it's pretty clear that that's my property, right? You would say that's my property. If someone hits you, batters you on the street, that's a tort. So we'd say that, that's, you can't invade my space. If you have a contract with someone and they renege on the contract, you say you broke the contract. See, these are very clear legal issues. With privacy, it's a bit more amorphous, and sometimes it's hard to understand what we're dealing with here. Normally in privacy, we deal in the area of torts, and so these are civil wrongs, but we're going to be talking about this law tonight. Just keep in mind as you're thinking about it, if it's a little amorphous, it's a little hard to understand and get your mind around, it's okay, because the law struggles with that as well. So, here is the slide. There we go. So this is where we're going tonight. So we're going to talk about what are biometrics, right? Some of you guys probably have an idea what that is. Any takers first? Anyone want to take a stab at what a biometric is? Biometric identifier. So we'll get there. We'll get there. Hold on, and then we'll talk about the background and language of BIPA. So as Ben said,
I'll take a stab.
You take a stab? Okay.
Biometrics are those indicators that are demonstrative of your behavior.
Okay.
Or your, what's the other one? It's your behavior or your
Identity. Identity, yeah, unique and permanent. So we'll talk about that, but that's right on. That's great. So this statute, BIPA, as I'll call it tonight, is a little bit easier than Biometric Information Privacy Act, but that deals specifically and only with biometrics. So one of the things that's important from a legal perspective is understanding the doctrine of standing. We'll talk about what standing is. It's a very deep legal doctrine. We're not going to do it justice, but we'll try to talk to it in terms of this issue and analogize where courts have talked about similar types of ideas. Then we'll talk about this idea of a person aggrieved. Okay, what's an aggrieved person? Maybe we have another idea what that is, but the statute, BIPA, talks about that a person under BIPA can bring a lawsuit against a private company, but it doesn't define who that is. It says aggrieved person. What does it mean to be aggrieved? We'll try to suss that out. Then we'll also talk about legislative initiatives. Right now, the Illinois legislature has a bill and some amendments that are trying to narrow BIPA. We'll talk about, and I'd love to hear your thoughts and see if that's a good thing or not. Policy arguments, we'll talk in terms of what are some of the pros and cons of BIPA and what are some of the arguments which animate this legislation, which is particularly important moving forward as more of our lives move online. And then we'll have some discussion topics and questions that I'll sort of tee up, and then I'll love to hear what you'll have to say. So, biometrics. The measurement and statistical analysis of an individual's physical and behavioral characteristics, such as behavior or voice patterns, so we had an indication of that with the answer, especially as a means of verifying personal identity. So there's a reason that biometrics are being used nowadays. I mean, obviously people are very concerned with their privacy, and companies are concerned about how we verify people's identity. Well, if you use biometrics, it's only going to identify you, which is a positive in that respect. They're unique and permanent to you. And so BIPA protects certain types of biometrics and not others. The statute specifically forbids certain types of biometric identifiers. I want to read this to you very carefully. BIPA protects the specific biometric information of retina or eye scans, fingerprints, voice prints, and scans of hand or facial geometry. So information, I've noted this very carefully here because in other states in the United States that have biometric pieces of legislation, they use the term identifiers, which identifier, if you're a tech savvy person, you can change to make it identify you through a mathematical equation. A lot of what you have online is done through certain types of codes to keep information secret. And so I could turn someone's thumbprint or their retinal or eye scan into some form of a mathematical equation and say it's an identifier. And therefore it's not actually the biometric itself. It's just something that identifies the biometric. But information is much more expansive because it's anything that relates in any way to that biometric. So it would capture that kind of equation, which is very commonly used in sort of computer science talk and how they would, I guess, classify people's biometric data. So another thing to mention here, it expressly excludes signatures and photographs. So those are things also that can be used as biometrics. The Act says, no, we're not really concerned with those. And the photographs is something to think about there because facial geometry and photographs, can't you get someone's facial geometry from a photograph itself and scan it? And there's been some I guess, different interpretations in courts about how to make those square that circle. So how are biometrics used? These are a few ways, and at the end we can talk more about other ways you may see as well. But time management, facilitating clocking in and clocking out. Obviously, employers have an interest in that, making sure the scan your friend in problem. Security access, different methods such as fingerprints or facial recognition. It's a one-stop shop for employee information, such as record keeping, credentials, granting access to certain areas of the company and not others. So we could say, hey, Joseph works at this company. Let's just give him access to this part of the company. We can have all his information here. It's perhaps more efficient from an administrative perspective. Also, health information. It allows a company to use aggregated risk profiles, which may be helpful for their business model or may be helpful for them to understand how their employees and try to help them be more healthy at work. Transaction authentication, that's a big one, right? Wouldn't it be nice, people steal their credit cards. Maybe if you could have your thumbprint tied to your credit card, then it would never be stolen. Or theoretically, this may be how it would work. And also more effective marketing. Some of you may ask, how does that work? Is that kind of scary? Well, sometimes you see these ads on Facebook or other places, and why is that ad targeted me? Maybe you'd like to see smarter ads, more tailored to you, as long as they're going to be ads anyway. So that's another useful, I guess, part of biometrics. So moving on, BIPA background. So it's interesting that we talk about the law, why things are passed. There's obviously in the Illinois legislature a lot of reasons why laws get passed. So I'm not trying to say here that there's only one reason, but there was one event back in 2008 where a company, Pay by Touch, an Illinois company, was basically one of the big thumbprint, fingerprint scanners in Illinois business model. And essentially they were going bankrupt. And the legislature became really concerned because in bankruptcy, someone can swoop in and buy the assets of the company and basically sold at fire sale prices. And the legislature became concerned, what if some, corporate giant were able to get their hold on all these private people's, all this information. So they were scared about that. Like I said, that's not the only reason probably, but privacy was the animating concern in terms of protecting regular citizens' biometric data. And so they were worried that the assets of a fingerprint company would be improperly used. For many years, 2008 seems like a long time ago, but I guess in some ways it was. But for many years, I guess probably until 2015, there was essentially no litigation around this issue. So BIPA allows private citizens to sue companies, and we'll talk a little bit more about this soon, to sue companies for aggrieved parties when they lost this type of information. There were 7 suits approximately in 2015, 7 in 2016, and then last year there were over 30. So why all of a sudden all this action around BIPA? Before I go to the next slide, I want you to think back to ancient times, right? Maybe your your middle school geography book. What do you think about? Well, this may not be what you're thinking about, but this is what I think about. This is the iPhone 3, Okay, 10 years ago, this was the iPhone, right? Seems so old, seems ancient. Not really. I mean, a bit of a joke, but you can see there's no thumbprint scanner, right? I mean, how the iPhones have that. It's really in vogue, and this is sort of where we were in 2008. This was a model profile page of Facebook in 2008, right? Many of you were using this 10 years ago. The interface is a little clunky. It's not what it looks like today with the video and all that, Facebook Live, here we are. This company here, I want you to keep this company in mind. This is called Face. There was a company called Face.com, and it was an Israeli startup, and they basically formulated a way to scan pictures and use AI to identify faces. And this company started in 2007, and then Facebook acquired this company in 2012. So when we're talking about what happened in 2008 in the Illinois legislature, biometrics was sort of a thing that not many people understood. But there were companies thinking about it. And so we'll get back to that as the talk proceeds. So we've talked a little bit about BIPA. It seems like kind of this amorphous thing. Let's get into actually the text, okay? What is it actually saying? So this is sort of the big part of this, which really distinguishes it from all other pieces of legislation in the United States with respect to biometrics. No private entity can gather and keep an individual's biometric information without prior notification and written permission from that person. It does not apply to government entities, right? Now, certainly government entities can use biometrics, and there's arguments maybe why that's a good thing. There's arguments maybe why that's a bad thing. But this statute doesn't speak to that. So the key features of BIPA are informed consent, permits a limited right to disclosure, mandates protection, obligations, and retention guidelines, prohibits profiting from biometric data, and this is the key one, and this is sort of what I'm doing this summer in terms of my research, is it creates a private right of action for persons aggrieved by BIPA violations. So I'm sort of trying to understand private right of action. That means the ability to sue companies. What's the scope of that? And how do we as citizens, how do we understand what the scope of that is as lawyers in order to understand what the Illinois legislature was really trying to protect? So we'll get into that a little bit later. The statutory damages, and this is where if you're a business person, you're really paying attention, right? Because it's $1,000 for each negligent violation of the statute. It's $5,000 for each willful violation. How those violations are going to be calculated or compounded, we never know, because we've never gotten to the point yet where a court is calculating damages. But you can imagine 1,000 times, 1 million people, say 1 million people have used Facebook or Google at some point during a specified time. This can be an astronomical sum, and it would basically put a lot of these companies out of business. And so that's one of the things that when we're talking about public policy, we have to think about, because how many times do you use Google a day? Right? And then you times all the citizens in Illinois, right? And if that's over a period of time, it's in the hundreds of billions of dollars. So I mentioned that there are other states in the United States that have laws with respect to biometric information. And there are only 2. So, Illinois, we're on the vanguard here. Texas and Washington are the only other states with laws regarding private entities' collection and use of biometric data. But both have no private right of action. So in those states, if there's a violation of the statute, the attorneys general of that state, which is obviously an elected position, will bring a suit, right? And normally, I guess, obviously different states are going to have different rules and regulations regarding their AG, but there probably have to be some public outcry of some kind for the AG to sue a company operating within Texas or Washington. So Illinois is the most restrictive law of any state in the country on this issue. And we've talked about how important biometrics are. So depending on your perspective, Illinois may be at the vanguard or maybe at the point where it's gone too far. So we'll talk about that. Now, I'm a law student. I'm studying for the bar. We have to talk about law, right? I mean, this is, it may not be fun, but how do we understand who can sue as a private right of action against these companies? And so we always go back to the Constitution in terms of where we get our authority for anything we do. Some courts maybe ostensibly don't, and if you're on the right or the left, maybe you see in some cases they don't, but that's ultimately where all authority for our laws is supposed to come from. So the doctrine of standing comes from Article 3, Section 2 of the U.S. Constitution. So I'm just going to kind of breeze through this a little bit. I've highlighted the key words, as you can already get, but I want to make the point. The judicial power shall extend to all cases in law and equity arising under this Constitution to the laws of the United States, and treaties made, or which shall be made under their authority, to all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of other states, between citizens of different states, and between a state or the citizens thereof and foreign states, citizens, or subject. So, newsflash, this is called the case controversy requirement, right? You've seen cases and controversy there multiple times in that paragraph. And so courts have interpreted that as saying, look, in order to bring a lawsuit, you have to have a real case, there has to be a real controversy. So how are we going to define what those words mean? This is what lawyers do all the time, right? We sort of figure out what words mean to their very core. Requirements for standing. So in terms of that case in controversy, federal courts have interpreted that to mean a plaintiff must establish the existence of an injury that is concrete and particularized and actual or imminent. That is neither conjectural or hypothetical, nor abstract, not abstract. And that's the first prong. Okay, so all of that is within one prong, one requirement, and then fairly traceable to the challenge action. And 3, redressable by a favorable ruling, means if I as a judge rule on this, is somebody going to be helped? Is there somebody going to get what they want from bringing this lawsuit? Respondents cannot, these are a couple other rulings that I think are key for us to understand when we're talking about standing. As I said, it's a huge, huge doctrine. But respondents cannot manufacture standing merely by inflicting harm on themselves based on fears of hypothetical future harm that is certainly not impending. So you can imagine, right, it would be bad for our constitutional system if someone just said, hey, I'm harmed, I go to the local court, right, I go to the federal court, and then they say, yeah, you've been harmed, let's make the company give you a lot of money, right? That could be too broad in terms of the power that citizens have over companies. Obviously, we want people to be made whole. That's language we sometimes use in the law, to be made whole, but it can go too far. And so the courts have to find a way to put a ring around how we understand harm and in terms of the laws that are written. Also, lastly, in data protection cases, which is somewhat similar to biometrics, right? It's sort of amorphous. It's out there in the cloud, right? And these type of other avenues that we use every day. Some statutory violations do establish concrete harm. So that's like, wow, huge for lawyers, right? Because a statutory violation is just if a company doesn't follow the statute, not necessarily if you yourself were harmed personally. What this decision was, which was basically taken from an appellate court, this is Spokeo 2, this was taken from a Supreme Court case. They said, look, that can be good enough for you to find harm in these data protection cases, which is similar to biometrics. So let me sort of for visual learners among you, I think this is important to understand where we are before we keep going. So I said the Constitution, right? That's the base. Look at the very top there. And then under that, I can't quite see here. So we have the case and controversy requirement. Then we have standing. Then we have injury in fact. And then we have imminent and actual, concrete and actual. And then we have this idea of aggrieved party. So all of this is really going down to the root, right? And that's where we are kind of interpreting all these things. So they all build upon one another. Now I should say at the end that aggrieved party, that's what the Illinois statute says. And injury in fact and all of this that we just read in those cases is what the federal courts say. Just like in life, right, Illinois courts are going to be very jealous and guard what their statute says, and federal courts are going to say, look, this is what federal courts have said. So sometimes there's a mixing of how those interact between each other. It gets a little complicated, but just think of it as a home turf war between the Cubs and White Sox, right? People get very jealous of these types of statutes and how to interpret them properly. So the first case, now we're getting into cases, right, to interpret all of that, which we've just talked about. So this is sort of the big case that's happening right now in federal court. This is in California. So this is called the Henry Facebook biometric privacy litigation. So there's a lot of cases where people sued Facebook over their tag suggestions program. So started back in 2015, and individuals were identified together when neither individual had instigated that connection. So you can imagine, all of you have probably seen this on Facebook. You see multiple faces, individuals, and they say, is this Johnny? Is this Jane? And you're like, wow, you sort of know that. And, I hadn't said that Johnny and Jane and we were together, but there it is, right? The class includes Facebook users located in Illinois for whom Facebook created or stored a face template after June 7th, 2011. So remember we talked about the BIPA protects against facial scans of geometry? So how many people have used Facebook within that time in the past 7 years? Probably everybody in this room. So that means that you have a right, you're part of this class, to be in this lawsuit and to perhaps have damages, to perhaps have money damages. It's a lot of people, many millions of people, and as we talked about with the damages, times many millions, billions of dollars, frankly. So this was just this past month. So this is very hot in terms of how things are going in terms of the legislation. But Judge Donato, who is a district court judge, which is the first level in terms of how federal cases are brought in the federal system, he ruled on this case that actual harm to plaintiffs was not the standard under BIPA. Wow, right? Isn't that interesting? We talked about, remember the federal, they said in that actual harm had to happen? And he's saying, look, whoa, you don't have to have actual harm. Facebook was very scared when they read this, frankly. I mean, and anybody who was a defendant in this case would be. Let me also read what what happened after Judge Donato said that. With the matters of fact at issue in the case, plaintiffs saying that Facebook is analyzing their face, and Facebook is saying that its process merely identifies each pixel in a picture, and the program learns how to identify faces. So it was saying it's not right for trial. So this is interesting. Remember how I talked about Face.com and this whole program that sort of learns faces? So Facebook is basically saying, they haven't necessarily argued these things at trial yet because they don't want it to get to trial, but they have this program that learns how to identify faces. So what Facebook is saying, look, it's just identifying the pixels and how your pixel and your colors interact with each other, and frankly, they maybe wouldn't say the facial geometry because that's what the law protects against, but they would say, oh, the distance here, and frankly, that is how a computer program would identify certain things. So Facebook was very scared when Judge Donato wrote this. They immediately appealed for a class certification petition in the Ninth Circuit. So there are certain rulings in law where you can do immediate petitions to higher courts to stay the ruling. And so Judge Donato said, look, we're going to trial. Right, this is right for trial. This has been around since 2015. All right, Facebook, you got to talk about how you're doing what you're doing. And Facebook said, we don't want to do this. So they went to the Ninth Circuit. That case is still pending. So we'll see how that turns out. But I talked about Face.com. Facebook, as you remember, bought the company in 2012. They named the company DeepFace, which is the pattern recognition, the facial recognition software for how their AI system learns. And so I want to be fair to Facebook. They're going to say that, look, it's just this computer system that's learning how to recognize what we as humans call faces. But if this were ever to get to a jury or in front of people that don't necessarily know so much about technology, or maybe know enough about technology to know maybe that's not the way technology works too, so there's different ways of seeing it, it's gonna come to light that this program is called DeepFace. So it's hard to say you're not actually scanning people's faces when it's called DeepFace. So that's something to think about, and that's how defendants really can get really scared, frankly, and so it's a reality. So this is another case, Rivera v. Google. Photos were taken from Rivera's Android device. I have an Android device, not an iPhone, but they all kind of work the same, and automatically updated Google Photos. Okay, so a lot of that's happened. We're all connected to data all the time, or Wi-Fi. The plaintiffs argued that their facial templates were then used by Google to find and group together other photos, right? Similar process, or at least for the layman who's using these phones, seems like a similar process to what we see a lot of the time. Judge Chang of the Northern District of Illinois, so now we have someone here sitting in Chicago interpreting an Illinois statute. He said there's a chance what Google is actually doing is not in violation of the Act, and perhaps discovery will resolve this. So what happens in court initially is that there are motions to dismiss a case normally, and if there's issues of fact which still need to be resolved, a judge will say, look, we've got to go to discovery, the legal term, to sort of understand what's actually going on here. And Judge Chang, I think, is, to his credit, is very charitable to Google. And he's saying, look, we have to figure out what you're actually doing if it's violating the statute. So what Judge Chang is doing in this ruling is he's not sort of focusing on standing. Remember, we talked about standing. He's not focusing on that. He's not talking about person aggrieved. He's saying, look, we just need to get to what the issue is here. And then, of course, when that happened, Google filed an interlocutory appeal. That's a form of an emergency appeal, similar to what Facebook did in the Ninth Circuit, to the Seventh Circuit, which is still pending. So, obviously, you know, and it's if you're representing Google too, they're represented by the former Solicitor General in this place, so they have good legal counsel. You wouldn't want people talking about how you actually do the photos, right? That's your IP, that's your intellectual property. So you don't want people necessarily, I mean, obviously it's all kept secret, but it's something you don't necessarily want to talk about. So moving on, Santana v. Take-Two. So we've gone through a couple cases that seem to be a little more favorable to people bringing lawsuits against companies. And now we'll talk about one where the court just really, they kind of slammed the door shut. And obviously, you know, this is America, there are always differences of opinion. Okay, so Take-Two is, some of you, this is a video games case. Take-Two is a publisher, developer, and distributor of video games. As a part of an NBA game, through 3D mapping, users could put their face on one of the players in the game. The process to do this took 15 minutes and required signing a user agreement. So you'd sit there in front of the TV, they'd map your face, and then when you're playing their game, you're like, hey, that's my face on LeBron, or I don't know, somebody. And but it required you actually sitting there, and it wasn't this sort of, you know, quick thing. Maybe that matters, maybe it doesn't. We can talk about that. Plaintiff argued, that's Santana, plaintiff argued that they had standing because defendant took facial geometry scans of their faces without sufficient written disclosures and adequate security protections. So, hey, you got my face. What are you going to do with my face? How are you going to store it? I mean, I don't want you giving my facial scans to other NBA games, or maybe the hockey game, or maybe the golf game, which the golf game would probably want that then because maybe I'd be more likely to buy it. So but, you know, what are you going to do with these things? You haven't told me how you're going to do it. Remember, the statute itself said you had to have those storage type of requirements. So the court said, look, allegations about storage misuse were too speculative and abstract. So now we're getting back to that, you know, we talked about standing, right? It has to be actual. And Santana v. Take-Two, this is the Second Circuit in New York, they're saying, look, it's not actual. I mean, there's no other game that's taken your face. There's nothing that's actually happened with your facial geometry. If that were to happen, it'd be a different story, but this hasn't actually happened yet. So what the court holds, and this is addressing standing, right? We talked about standing. The Second Circuit Court dismissed the BIPA claim because the plaintiffs failed to allege a risk of a concrete harm under Spokio. Mere technical allegations of the statute were not enough. So we had the Judge Donato saying, look, it doesn't have to be actual. And then we had this court saying, look, it has to be more than just a mere technical allegation. So something to think about as we move forward in the presentation and discussion time after. Does the fact that the plaintiffs knew that their faces were being used matter? I mean, they knew they were being used, but there was no process for storage of them. Does that matter? Or do they sort of implicitly consent, and now they're trying to get damages after the fact? Just to be cynical, which lawyers sometimes we are somewhat cynical. Okay, so that's all standing, right? Judge Chang, remember, Northern District of Illinois, he sort of didn't talk about standing, but that's sort of what he's trying to get to here. Now we're talking about person aggrieved. What does that mean? That's actually what the BIPA text says, aggrieved persons. But all of the cases which have examined what aggrieved means, they've all held that it means you have to have an actual injury. So similar to the Santana ruling that we just went over. So this is sort of the key case, the big case in Illinois. It's at the appellate court level in Illinois, which is the middle. It's similar to the federal system where there's 3 levels of courts. And so this is Rosenbach v. Six Flags. This was just December of last year, so pretty recent. And the plaintiff, Stacy Rosenbach, bought a season pass for her son, who was fingerprinted without obtaining written consent or disclosing a plan for collection, storage, use, and destruction of his information. So wow, like, it's a normal thing, your mother buying something for your son is a very nice thing, but hey, how are you going to use his fingerprint? How are you going to use these unique and personal identifiers to him? Rosenblatt claims she never would have purchased this pass for her son if she had known of Six Flags conduct. We don't know if that's true. Maybe she's trying to get some money out of it, but there are certainly, if not her, there's a lot of parents out there who would very much care about that. So it's legitimate in that sense. The court said that in order to be aggrieved under the statute, you have to have suffered actual injury. There's that word again, actual injury. Meaning that Six Flags' technical violations of the statute do not suffice to confer standing. But then the court threw in this sort of curveball. They said that in order to be aggrieved, you don't have to have a pecuniary harm, which means a monetary harm. Maybe it could be an emotional harm. Maybe there could be other harms other than just monetary damages. The court doesn't suss that out for us. But it's also very clear that a technical allegation, similar to what we read in Santana, although that was on different grounds, is not sufficient to confer standing under the statute. So this month, just a few weeks ago, the Illinois Supreme Court said they're going to hear this case. It's on appeal. Will they uphold this type of interpretation of Rosenbach? Will they go with more of an interpretation in the Facebook case out in Illinois, out in California? We don't know. But however the Illinois court the Supreme Court rules as the final arbiter of Illinois law, will be binding, theoretically, on other courts around the country, right? You could still have a judge say, look, I think the Illinois court really was saying this, and we could still have problems. But this is a very consequential case, and we don't know precisely when the Supreme Court will rule, but it's a huge deal they've taken this case. So I want to give one more case. This is Monroy v. Shutterfly. This is not really in the standing bucket. This is not really in the aggrieved party bucket, but I think it's important to talk about. So similar fact pattern. A user argued that Shutterfly used his facial geometry without giving him required notice and consent. He argued that this is in violation and invaded his privacy. Wow. Privacy, that's a big word, and it comes with a lot of connotations, comes with a lot of different intuitions. Judge Gottschall, this was in the Northern District of Illinois as well, she said that there was no emphasis in BIPA on showing adverse effects. Adverse effects, is that actual injury? It's not really clear. That actual damages are necessary in order to state a claim. So she seems to be more on this side of, look, people are harmed maybe in some way. They're adversely affected. So it didn't focus, as I said, on standing or aggrieved. The court talked about in dicta, that's what we say in law, sort of the part of the holding that's not central to the reasoning, but it's also something that subsequent courts will pay attention to. She said in this opinion about the implications of technological developments on how data might be generated from photos. She actually said in it, she said, look, okay, maybe they're not actually scanning faces right now, but that doesn't mean we can't predict what's going to happen in 10, 15 years that actually could be happening. And isn't that really sort of what BIPA was trying to protect? Not necessarily what the technology is today, but what the technology can be. And so it's more about protecting this fundamental right to privacy in all of its manifestations with respect to biometric information. So very interesting words there from the judge. So we've talked about cases. Now let's talk about what the legislators are doing. Legislators, right? After all, they're the ones who passed this, right? 2008. So there's a bill currently in this legislative session, SB 3053, and it narrows BIPA for entities that collect biometrics exclusively for employment, HR, fraud prevention, or security, collect biometric data but do not sell, lease, or trade from such information, which in my interpretation seems to be already banned by BIPA as it stands, but they, I think, want to make that very clear. Collect, store, transmit, or protect biometric data in a manner in which the entity handles confidential or sensitive information. So that's sort of what it's meant to protect and really kind of narrow so companies really understand, when can I be sued, when can I not be sued, what I actually have to do with data. There's an amendment which even narrows it further, and it says, look, digital photographs would be expressly excluded. So, hey, wink, wink, Facebook, Google, these kind of big companies, what you're doing with photographs, that's going to be okay. We're going to explicitly say that's okay. Why they're doing that, who knows? Obviously, politicians get donations. A 2016 bill, now we should keep in mind that just 2 years ago, there was another effort, similar to this one, to limit BIPA. And privacy activists said, no, we like BIPA as it is. Illinois is at the vanguard of this very important issue. The people who introduced it at that point in time introduced it a week before the end of the legislative session, which, seems like you're trying to sneak something in, maybe with this important piece of legislation, but it was killed. So we've talked about actual injury, and I know I'm getting to the end, so stay with me. Types of potential harms in biometric cases. Okay, these are some harms we can talk about. Other ones you may see or may not see. Emotional distress. Maybe you're worried about what's happened with your biometric information. Increased risk of future harm, ID theft and use of stolen identifiers, and compounding risk of theft and use of remaining identifiers, right? You only have a certain amount of biometric identifiers, right? You only have a certain amount of thumbprints. So if somebody steals that, you can't manufacture another one. It's different than if your data is stolen with a password for your credit card company, for instance. Change a new one, try to put your life back together. Precautions to reduce risk of future harm, time and money. So you've got to figure out who are the experts to help me protect against myself. And that incurs cost. Remember we talked about how you can't manufacture standing. So this is kind of one of those areas where you can't go out and incur $3,000 of cost. Obviously it's very fact dependent in law. So we try not to give judgments about how a case would turn out. But you have to be careful that you're really spending money that you need to protect your biometric information. But it's certainly a type of potential harm. Potential liability for fraudulent misuse, right? Well, after all, this is your thumbprint, right? Only you could have done this. Well, and it becomes this whole thing. We have to sort out different things which happen with your information. So there may be others we can talk about. So this is where we've been. We've talked about BIPA, and I can't quite see this that closely, so I'll just talk about where we are. Biometrics in terms of what they mean, how they're defined in the statute. We've talked about the BIPA, like the background of BIPA and how it sort of had come to be. We've talked about standing, its importance in our constitutional architecture, and how that, with the constitutional foundation of the Constitution itself, forms the basis for this piece of legislation. We talked about what it means to be an aggrieved person, and then we talked about different legislative initiatives and maybe some of the policy implications of BIPA moving forward. So I want to give you this closing thought, and then I'm going to kick up some thoughts for us to talk about in discussion. So this woman, her name's Sarah Guo. She is a venture capitalist in Silicon Valley. She's a very obviously successful woman. She works with some of the most cutting-edge technology in the world. Venture capitalists take very risky investments on new technologies that we probably won't see in our daily lives for 10, 20 years down the line. And so she's privy to some of the most, classified things and cutting-edge things in technology. And she said this quote a couple weeks ago in response to someone talking about privacy. She said, "It's not my fault what the future holds, so if it's scary, I apologize." And this is a very intelligent woman, but I really push back against that notion because we as citizens need to take steps to protect our privacy. And if we outsource it, and that's why this institution itself is so important, right? It's important to this community, it's important to Illinois, it's important to the country, because if we don't take steps to really sort of have, a say in what's happening with privacy, then, companies will decide this, and then at that point it may be too late. Before I close, I just want to, these are some things that for you on Facebook Live at home to think about, and also discussion topics for us to talk about in the next few minutes. Whether Congress should pass a federal statute creating a unique tier of standing for biometrics. They've done this with other types of standing, right? There was a case called Massachusetts and EPA where the Supreme Court said, look, if you're an organization or if you're a state, you can sue on behalf of the EPA violating and having pollutants, right? Where it's like, yes, I'm sort of harmed, but is that really actual harm? Because I'm not necessarily being polluted, personally to me. There's also FOIA requests. This organization works with FOIA requests. You don't actually have to be harmed in order to have a FOIA request. You can just be curious about something. Is biometrics similar? Discuss the patchwork of laws in the U.S. related to digital information. That's something we can do if you'd like. How does data held by private entities interface with the Fourth Amendment, which applies to government actors? There's a certain standard for the Fourth Amendment. Maybe that's a certain standard that we should apply to private companies. That's something that may take a constitutional amendment, but it's worth talking about. Are there problems with network effects? So network effects, this is idea that increased numbers of people using a good increases that good's utility and value. As more people use a site on the internet, it becomes more valuable because it connects more people and fosters more interest. So obviously Amazon would not be as valuable if it was just the city of Elmhurst, right? But because it's so much larger, then other people can sell goods and, wares, so to speak, and it becomes more valuable because of the network. But is there a point where the network becomes so big that people can't really get out of it? And this is sort of the problem, I guess maybe the tragedy of the commons in terms of how we think about goods in our private society and how they may have negative externalities which affect us as well. Innovation for protection of specific kinds of privacy. The Amazon headquarters, right? Our mayor is really in Chicago, is really trying to push for this headquarters, and they're a company that's on the cutting edge of a lot of biometric information. Should we try to narrow BIPA to perhaps appease corporate entities? I mean, they could go to another state. Or is that something where we should really focus on ourselves first, and companies can decide based on their own other judgments about how they like to make a decision where they like to expand? Specific legislative fixes for BIPA. Anyone wants to talk about those? I'd love to hear them. And then we can talk about the theoretical underpinnings of privacy law and our intuitions about what it should be. Some of you are going to be like, hey, look, Google and Facebook, they identified me on these photos. That's no problem. And some of you will be like, oh, wow, that's terrible. So I think we should talk about those things because people are going to have, I think, strongly held views about how these things interact with our daily lives. And then the last point is how much of the data we use is ours or reasonably can be said to be ours. So hate to break it to you, but in terms of us saying that our data is ours, that ship has it's really sailed. I mean, it's not so much whether we own the data now, it's what kind of data people know about us. So are there limits? And that's really the new, I guess, frontier in privacy law is, basically how we ring fence around what we want to be protected and what we don't. And is there a reasonable expectation of privacy in how we interact with our daily lives? Obviously, we walk down the street here in Elmhurst, we're going to have an expectation that if we're being watched, it's for public reasons, right? Because of safety concerns. But if you go in and if you look at certain storefronts, you would never think that then you would see ads later on the internet that you've seen those storefronts. But when you go on the internet and you see things on Amazon, you will see ads for those things. So it's in a different setting. We sort of have different expectations. And should those be different, we'll talk about it. So thank you very much. And Facebook Live, thanks for tuning in.